Welcome and thank you for joining me for Tax Break. This is a podcast about South African tax for South African tax professionals and practitioners. My name is Pieter van der Zwan, and in each episode I share my thoughts on a topic or a recent development in the field of South African tax with you. And as always, I'll do my best to do it in the time that you need to make a good cup of coffee if you need a bit of a break from work. Our question for today is, if you detect an error in a tax assessment, should you use the objection route to try to rectify that error? Or is it better to use the Section 93 mechanism that you find in the Tax Administration Act? Before I share my views on this choice with you, I would like to just recap on the provisions themselves, or the two processes. If we look at the objection on the one hand, that's the process that's available to a taxpayer who is aggrieved by an assessment. And that's probably the more familiar process. So I would say that that's the default, that if there's something on a tax assessment that the taxpayer is unhappy about, this is normally the default route to address that. Section 93, on the other hand, that's now a provision of the Tax Administration Act. It caters for several instances where SARS may issue reduced assessments. What's important about Section 93 is the legislation specifically states that it's not necessary to lodge an objection or appeal. So it's a separate process outside the objection and appeal process. And the specific provision that we would be looking at today is Section 93(1)(d). So that provision allows SARS to make a reduced assessment if there's a readily apparent, undisputed error in an assessment. Now, by just looking at these principles as to when these two processes apply, I think there are obvious cases when they don't overlap. So, for example, if you've got an additional assessment that SARS issued, it's, for example, say there's an amount that they consider to be taxable that you don't, or there's a deduction that they've disallowed that the taxpayer claimed. That's not an error. That's a difference in position or interpretation, and it's also not undisputed. So SARS has got one view, the taxpayer has got a different view. So in that case, the objection route is the route to go. If the taxpayer becomes aware of an error, I think that's when the choice arises to say, but should you use the objection route or 93 to correct this error? The first important point here is that there's nothing that prevents you from lodging an objection, even if the reason for the assessment that the taxpayer is aggrieved by is an error by the taxpayer himself or by the tax practitioner. So you can object against an error that is your own doing. Section 93 has got a few more requirements. So you need to firstly ask yourself the question, am I looking at an error? Is this error readily apparent? So is it an obvious error in, I guess, plainer language? And is it undisputed? Now, I think that then links well to say, which of these two would be the best route, seeing that there is a bit of complexity in the wording of Section 93. I'm going to share my views with you on what's good and bad about the two routes, and I'm sure that there would be others with different views as well. If we look at it from a timing perspective, like the objection process, Section 93 has got a 3-year limit on during which you can request this correction. However, if you compare it to the objection process, if a taxpayer wishes to object against an assessment, you need to lodge that objection within 80 business days from the date that the assessment was issued. It is possible to extend it, and depending on how late the objection is, you would need to either provide reasonable grounds or in some cases, exceptional circumstances to motivate why SARS should still consider your late objection. So, in short, the Section 93 process doesn't have any, whether you're submitting on day 30 after the assessment was issued or day 300, the process remains the same. Whereas if you want to use the objection route, you may need to request condonation. So the timing of when you detect the error and when you correct it plays a role. Assuming that timing is not a problem, or you believe that you've got good grounds for SARS to condone the late objection, if we look at the mechanism itself a bit, an objection would, irrespective of the reasons why there's an error, whether an objection is successful or not depends on the merit of the case and the grounds of objection that you put forward. Section 93, on the other hand, you've got, as I've already mentioned, a few more hurdles. So you need to prove that the error is readily apparent. You need to prove that it is an error. You need to prove that it is undisputed. And as you can imagine, these terms are susceptible to different interpretations. So there could be, depending on the facts of the case, a few more hurdles that you face once you are into the Section 93 process than, for example, the objection process. If we look at the practicality of the process, so the process itself, if we look at the objection side, it's very structured. The law provides for a number of days within which you need to file the objection for SARS to respond, for SARS to give you a decision on it. And the objection is normally done through e-filing. So it's a very structured process. Section 93, on the other hand, is not necessarily that. So I think recently there's been the function to request a Section 93 reduction was introduced in some places on e-filing, but it's often a request that happens outside of the e-filing system. Unlike the objection process, for Section 93, there's no specific periods to say, but within X number of days, SARS needs to give you an answer. Or if you don't agree with that answer, what do you do next? So it's less structured, and I think Section 93 could be a more tedious process than, for example, the objection. It's something that might need a bit more effort to keep it going, to follow up, to track what the progress is, and to find a mechanism to get that process going again if it, for whatever reason, stops. Right, so in closing, I think it's fair to say that there are pros and cons to both using an objection and Section 93 to correct an error. And the choice as to which route is best for you will depend on the facts of the case. I think it would also involve some strategic planning and possibly considering some of the trade-offs between a process that may be easier, but once you're in it, where you could face a bit more obstacles. I think it could also be from a strategic perspective to say that if you follow the one process, you are possibly closing the door on the other one. So, for example, if you do an objection, it's unsuccessful, it may be very difficult to then go the Section 93 route, seeing that there was a dispute that came out unfavorable. So I think it could be difficult to argue that it's an undisputed error then. So these are all the things you need to overall balance to make this decision as to which route you or your client should be going. That's all for this episode. Thank you for listening. And if you enjoyed the podcast, please subscribe on your podcast platform and tell all your friends and colleagues about it. If you have any questions that you would like me to discuss in a future episode, you're welcome to email it to me. My email address is in the show notes. And as always, nothing in this podcast should be construed as tax advice or a substitute for fact-specific tax advice. Until next time, goodbye.